So I wanted to introduce everybody, if I could. One of the main questions that we've been getting a lot here over the past few weeks. And by the way, Christina, if you could, when while anyone else might be chatting, hit mute if you could over the center bottom. It'll prevent any feedback issues, which will really help audio. We've had a lot of questions about the new FMLA laws, the FFSCRA, I think you said it was called. Probably butchered that, but nonetheless, and how all of that interacts with everything that's going on. And so we've had a lot of questions of doctors wanting to understand, how do they navigate this tricky bit of law? How do they apply it to their circumstance? How do they honor the law when it is appropriate to be honored? And how do they not have to deal with it when it's not appropriate to have to deal with it? So in an effort to do that, we brought Rihanna in from HR Branches. Rihanna's company, if hopefully I'm not going to butcher any of this either, is a company that specializes in outsourcing all HR issues. So if any of you watching have any questions relative to HR issues, you don't want to have to deal with your HR issues, you would just love to let some other person who's an expert who deals in them every day do it, she is going to be your winning ticket. And we'll put all their contact information in the comment section so you can see it. And then also joining us is Christina Gilbertson. And she is an attorney that specializes in HR law. And these two tag team all the time. So whenever it gets highly technical or legal, she brings Christine in to be her backup and expert. So you know that you're getting great advice because they can bring either in. And the beauty for us here today is between the two of you, we have absolute experts on all of this stuff. So pretty excited to hear that. Apparently the audio is very muffled, so I need to speak up. I am seen in the thread, or I just need to shut up and let you guys all do it. So with that being said, do one of you two want to jump in and sort of take over and go from there?
Christina, why don't you go ahead and get started with just the basic outline of the Families First Coronavirus Response Act?
Sure. So the Families First, I'll just call it the Families First Act because it's a mouthful otherwise, and that just makes it easier for me. So it went into effect April 2nd, so we are dealing with it right now, and it is currently slated to go through the end of this year, so December 31st of 2020, and it is applying to any business of 500 or fewer employees. And basically what they're doing is they're expanding the leave options, and whether it's paid sick leave or leave under the FMLA, to employees that are dealing with COVID-related issues. And so for under the Emergency Paid Sick Leave Act, then an employee, as long as they've worked for the company for 30 days, then they can take up to 2 weeks time off. If they themselves are symptomatic and being medically treated for COVID, if they are treating someone or taking care of somebody else as a family member that has COVID, if they are medically recommended to self-quarantine because they may have come into contact with someone else that does have COVID, if they're taking care of their children because schools are closed or the daycare is closed, anything like that. So these folks can take some emergency paid time leave, take leave off, and that's something that is difficult for a lot of our small businesses out there because a lot of small businesses don't have a lot of employees to begin with. And so taking people out of the loop makes it difficult for businesses to run. But this is something that is required. There are some limited exemptions that I think we'll get into a little bit later. But it is definitely something that is first and foremost on the minds of our small business folks for sure.
Awesome. So I'll jump into some of the Q&A if I could. I think it'll be helpful. One of the challenges that people are running into is obviously they have some employees who are just coming to them going, hey, I think I qualify for this. Can I just take it? And so the question, I guess, would be, what are the litmus tests that the employers can use to talk to their employees about, yes, you qualify, no, you don't? What are those things that we can offer them as a roadmap to successfully navigate this so they don't get in any trouble on either side of the fence with this topic?
That's a great question. I think that the first thing is to sit down with your employee and ask them, well, what's going on? And let them do the talking. Well, I feel like I've got the symptoms of COVID. Okay, great. Have you gone through the testing phases? Have you talked to your doctor? Do you have a doctor's note? If you're going down that path, asking the right questions is essential, that litmus test, as you say. So go down the path of asking them how this applies to this legislation through understanding their degree of COVID-related symptoms or issues. Really, in order to qualify for a lot of this, you will need doctors' documentation underneath FMLA or even the sick time. You will need that documentation. It will help you as an employer, and it will help your employee stay legally compliant. Now then we've got the second component where you've got the child care component. Either their daycare and or their school is shut down, and so they don't have a care provider for their child. This one's kind of pretty easy. Either A, you have access to daycare and it's closed, or B, you don't have access to daycare and the school is closed, so you're unable to have any type of available child care. You can also request documentation proving that your child's child care is also unavailable. Christina, anything else to add?
No, I think you hit it pretty square on the head there. I would say if you're not sure, you're kind of on the fence, I would err on the side of giving them the paid time leave, just because there are penalties if you don't comply with the Families First Act, and you don't want to find yourself on the wrong end of a claim there. Penalties can be monetary and imprisonment, even in some cases, if you're a repeat offender. So you don't want that to happen. And then you can have a fine that you're dealing with, as well as actual damages to that employee. If you wrongly deny their leave request, then you could be found liable and have to pay them not only the money that they would have been entitled to, but also basically double that amount. And so in a lot of cases, it may not be worth putting up that fight right now, because there are some caps on the amount of money that need to be paid out to folks under these leave and sick leave acts. And so, like I said, if you're on the fence about it, it may be difficult, but if you really want to just steer clear of having problems and finding yourself on the wrong end of a claim, then I would definitely recommend you go ahead and grant the leave.
Well, and it seems like a good time to address the tax credit side of the conversation, because a lot of the reason why someone might not want to grant it is because they're afraid of the cost involved in the whole process. So I think them understanding how they can recoup and what they can recoup might give them some peace of mind around this topic. If you could address that.
This is actually the really good news behind this act, is that this act allows for 100% tax credit. And it's almost, well, I can't say almost immediate, but it's fairly quick that you receive this tax credit because it's all applied through your payroll. If, in fact, you do experience an employee who does qualify underneath the extended sick leave or FMLA, all you simply have to do is contact your payroll provider and let them know that you do have an employee. Tell them which employee it is, how much you're paying them, fill them in on all the details and the agreements, and then they will actually start working on the back end and setting up that payroll tax credit. So you can actually see that tax credit come into play. Depending on how you have your payroll taxes set up, your payroll tax payment set up, is when you will start seeing that credit applied.
So
if I may, sorry, Darren, can I back up a step? I understand the tax credits. I'm going to give you a real live question from a doctor in South Dakota. He says, our state says that if we call our employees back to work, they no longer qualify for unemployment benefits. That part's easy. But it also says that if they claim to have school-aged children, that they can stay on unemployment even if we call them back. This is the majority of his staff. So his question is, would it be better for him to provide his own child care and pay for that so he can have a team so he can go to work? Because most of his team is challenging him that we don't have to come back to work because we don't have child care.
I think that's a fair assessment, and he needs to determine as an employer if it's worth it for him. If that investment is worth it, I encourage all employers to get creative in finding ways and getting back to business. The fact of the matter is that all of us small business owners have to get creative today, and childcare is a real concern for a large portion of our workforce. Some of us have the luxury of bringing our kids to work. Some of us don't. And running a dental office is a pretty hard place to have your kids come to work with you. There's a number of issues there. And so if he sees that there is an opportunity to provide childcare for his staff, he should definitely investigate it. However, I would say he should talk to an attorney and talk about that liability associated to the business in providing childcare. Christina, I think you could probably piggyback off of that one.
Absolutely. He needs to be sure that he's careful, that he's not saying that you have to put your child in my provided childcare opportunity there, because I mean, as a parent myself, I don't want somebody telling me where I have to have my child go. But if it's something, I think that would be enticing to a lot of his employees, because I know most states, when you're on unemployment, you're not usually getting your full salary or your full pay. And so if that's an opportunity for them to be able to make a little bit more money and have a place where their child is, I think that's a good place to be. But definitely there are a lot of logistical and liability questions that pop in my head in terms of where are we going to be having this held, making sure we're still complying with all the social distancing and the regulations and the limitations on gatherings and things like that. So I don't think it's necessarily going to be an easy investigation, but I think it's something that is worth looking into and see and kind of weighing the options there versus the cost and the liability and all of those things there. So definitely it's a good way to get creative, and I like where people are thinking with that, because like Leanne said, we're all getting creative. We're all trying to figure out how to make things work, and got to do what we can.
And to add a cherry on top, you're giving parents time away from their kiddos.
You raise a good, by the way, we will be including your contact information for both of you in this feed. So if people have specific questions, you can literally hire Christina to answer all those questions specific to your circumstance and get quality legal advice, rather than me just running off at my mouth trying to answer a question that I'm not really qualified to answer. But you raise a great question when you were talking about pay. One of the challenges we're also hearing is that some of these employees are literally making more on unemployment right now than they are coming back to work. And it's causing some frustration that there are some people that are like, hey, I don't want to come back to work. I'd rather stay at home and actually make more money. What's your advice on how to navigate that? Because not only is it an employee morale landmine, but I could also see there being some legal landmines as well.
Well, employers have to remember one of the very first aspects of qualifying for unemployment is that the person on unemployment has to be available and ready to work, especially when it comes to job attach or furlough, well, any situation, but especially when it comes to the job attach or furlough, when that employer is expecting that employee to come back, they do have to be available to return when that employer calls them back to work. So even though they may be receiving higher wages on unemployment, they become disqualified for unemployment the moment that the employer makes that request for them to return. Beyond that, you're absolutely right, Darren. It does pose a morale issue, but it's easily addressed if you have good conversations with your employees, if you have a good relationship with your employees, and you let them know that they are in fact valued and that you need them. People need to be needed, and they do want that emotional connection to their work. And so if you provide them with that, it does help. Have that conversation and listen to them. If they come to you and they say, hey, listen, I'm having a hard time. I was making more money on unemployment. Hear them out. You don't have to give them a raise, but you do have to listen to them and let them know, well, that's fine. But unfortunately, the fact of the matter is that it's time for you to return to work. Unemployment did pay this, but it just ran out. You are no longer qualified for work. You have the option of returning to work to me, or not. It's up to you, but at least hear them, let them make their own choice as to whether they want to return. But at that point, they no longer qualify for unemployment.
So should they choose the or not option, how is the appropriate way to navigate that?
When you say the or not option, so if the employee chooses not to come back to work,
Yes.
that's very simple. It's time to start looking for someone to replace that seat. And there are a lot of people who are unemployed right now who are looking for good work. And I hate to say it, but the likeliness of you finding someone better and more committed to your workplace is very high right now. You likely will find someone who would be excited to come back to work for you rather than unmotivated.
So do you literally have them resign their position in that circumstance then? Or do you have to terminate them and thus they get to go back on unemployment? How does that play out?
This would be a resignation because they choose to depart from the employer.
Got it. Because I think that's probably the biggest question that we've run into is what if someone says, no, I'm not quitting, you'll have to fire me. In some ways, you'd be sitting there going, I can't fire you. You're not coming back. So thus you've given up your position.
Yep. And that's in the case of a no-call, no-show, right? We've all dealt with, in many cases, no-call, no-shows. If they refuse to return to work and they don't come back to work during their scheduled time frame, then that's considered a resignation. That is not a termination. Christina, do you have anything to add?
No, that's exactly what I was going to say. I would just make sure that you're documenting that you reached out to them, said, hey, let's come back to work. Here's when I need you to come. And then if they don't show up, just make sure you're documenting that. And just in case they try to come back and still try to claim unemployment or that you terminated them, just make sure that you have a good paper trail that protect you if that were to happen. But absolutely, that's a constructive resignation. They can't force your hand like that.
I have someone who posted a comment of what if someone wants, you ask them to come back to work, but the hours are reduced. Is there a short-term unemployment? How does that play a role?
Yes. So with the unemployment, it can be for reduced hours. It doesn't have to be an all or nothing situation. In most cases, if they were working 40 hours a week, now they're working 25 hours a week, then they could get some unemployment that bridges that gap from the 25 to the 40 hours a week. So that is still an option for folks.
So partial unemployment.
I'd like to add, though, with some states, you do have to apply for that shared workforce program through your unemployment program through your state. It's generally called job sharing for reduced hour unemployment, and you might have to apply for it. So do check with your specific state. I know the state of Colorado does require it, the state of Texas, and a few others, but there are some states who just flat out pay reduced hours.
Okay, I've got a different kind of question. We say that there's a dental team of 12, and one person is in a high-risk health situation. She's healthy, but she's high risk. And she's also getting more on unemployment. She speaks to her employer, and the employer decides for her to stay on unemployment, but they're going to bring in everybody else. Where do legal liabilities lie here, if any?
For something like that, if she is a high-risk person, then I think what I would recommend is that she get some sort of a recommendation from her doctor that says, we're recommending that you self-quarantine just because you are at high risk, and then that kind of eliminates the issue there. I think that would be the safest way to go, because you don't want to look like you're playing favorites and discriminating against the less susceptible. I mean, there's a lot of gray areas these days, and there's a lot of things that are just a little bit different. But I think that getting that medical recommendation to self-quarantine, that then kicks in the Families First Act for you.
Okay, thank you.
Clarification on that, because I hear you saying self-quarantine, because them saying they don't want to come to work because they're high risk is not quarantining, right? There's a difference between those two. Me just not wanting to take the risk because I have some condition that makes me higher risk, I would think would be dramatically different than the term self-quarantine.
And that is absolutely true. And the Families First Act specifically spells out that If you're just self-quarantining because you don't want to be there, then you do not qualify. It has to be a medically recommended quarantine.
Hence the suggestion of go get a doctor's note then. Understand.
Correct. Yes.
Would this carry as well, nomenclature wise, if someone is just scared and doesn't feel safe?
I think that it would, unfortunately. And I know people are dealing with that a lot right now because there is a lot of uncertainty and people just don't know what's going on. But I haven't seen anything that would do a carve out for that would make that applicable. That's a tough one, but I think that if they're scared, they're still making that choice. You know, they're choosing to stay home. It comes down to that choice versus being told by a medical professional or a governmental quarantine or mandate to stay home. I think it feels icky, for lack of a better word, to be forcing somebody's hand like that. But at the end of the day, it is a choice on their part.
You know, relative to kind of the same thing, we've got a circumstance where we have an employee in an office that has not adhered to the social distancing models and suggestions, and the doctor has, because of that, had the employee not coming into the office because he deems it to be a higher risk because she's not followed the protocol that's been handed out by various government entities. Talk a little bit about the liabilities for the employer in that circumstance. What are the employer's rights if he's trying to protect his team and his patients from somebody who's not following advised protocols?
You know, the doctor did a great job in looking out for his interest. There's a lot of liability associated to not having employees following proper protocols right now. Social distancing is essential in any business that's in any form of operation right now, especially when it comes to human contact. And all social distancing practices need to be observed. And if they have protocol and policy in place that does need to be practiced, because let's talk about the liability. What if a patient were to come into your practice and contract COVID because you didn't practice, you or your employees didn't practice proper social distancing? We could look at a number of lawsuits in the future, and I think we will see some where you can track where that COVID case was contracted, and if it was a business, there will be a lawsuit. God forbid if there's a death associated to that COVID case.
So then relative to that, if the employee continues to not adhere to the protocols handed out to the government, social distancing is just one illustration, at some point the doctor, because she's always on a 14-day self-quarantine because of the risking, at some point I assume he's going to have to just dismiss her. Is he incurring some sort of liability, especially if she's claiming that she has a protected reason, such as religious views, to do that? Or does that not qualify because all social distancing trumps all of that?
Let me just clarify. So the doctor asks the employee to no longer come to work, and then I'm not following the religious.
It's at a church.
Oh, okay. So this isn't a dental practice. This is a church. And so she's not practicing social distancing due to her faith beliefs?
Because she continues to go to a church that apparently is getting a lot of national recognition for fighting and ignoring what's going on. And she's a very active person in that church, which is great. And I don't think the doctor clearly has no issue with that, but he has an issue with the fact that she's not participating in social distancing protocol and thus is bringing risk back to his business.
I'm going to defer to Christina on this one. This one sounds interesting.
I had a feeling it was coming my way, I think. That is a really interesting one. There's going to be so many one-offs and specific things. We could come up with a million different possibilities of things, of people doing things. But that is you're in a hotbed of a lot of different issues right there, because, like as you mentioned, you don't want to be discriminating on somebody's religious practices, but at the same sense, you don't want the liability on the other side. So I honestly, I would have to give that some thought and kind of do some digging on that, because I don't know that there's an easy answer for that. Because if it's initially, I was thinking that they weren't practicing the social distancing within the confines of doing their job, and that's absolutely a terminable offense, especially if you have, at this point. But what they're doing outside, yes, it is impacting potentially what happens within the office, but that's a good one. Let me give that some thought, and if I come up with a better answer, then I'm not sure, then I will definitely chime in with that. But that is a very specific issue, and one that I'm sure is going to be an issue at some point and may ultimately end up in a lawsuit somewhere along the line for sure.
My advice was buy an HR insurance policy. About $2 million in coverage.
Sure.
I have another question here. Someone posed of one of my employees thinks that because the employer got the PPP loan that they have to pay them even if they do not come back to work. I'm pretty sure the answer is no, they do not. You're both shaking your heads no, but I can't hear you, so I'm going to go with
No, they do not. Underneath the PPP, and I've actually had a lot of conversations with my clients about this. Be smart as a business owner. Even though you get the PPP, it does not mean that you need to bring back your workforce in full immediately. Be smart about who you bring back and when you bring back. If you don't have work for them, don't bring them back. Yes, under the PPP, you have to spend 75% of your loan, in essence, on payroll. However, it doesn't dictate who you spend it on, and it's not going to be tracked through Social Security numbers. You do have to do that, right? So 75%, the latter 25 can be spent on other forms of bills, rent, utilities, so on and so forth. But also factor this in. If you were to bring back a problematic employee or pay an employee for non-productivity, for sitting at home when they could be collecting unemployment, is it worth it to your business? Or just taking that cheap money and not the forgivable side, is that worth it versus that cancer employee? Look at all aspects of your employment base and make smart decisions. Don't feel trapped in bringing back employees immediately just because you received the PPP.
I want to clarify one point you made, if I could, that you're supposed to spend 75% on payroll. My understanding is you're supposed to spend 75% on payroll if you want it forgiven. If you don't use it for payroll, which would be, I assume, your choice, it's just you're going to have to pay back some prorated portion of it. But there's no law stating it has to only be used for payroll. Is that a true statement?
You nailed it, Darren. That's exactly correct.
Okay, just want to make sure. Have another question here of, does the employer have a right to keep an employee unemployed? I presume furloughed, it would be probably the question being asked here, for a longer period of time. I'm pretty sure the answer, as you just indicated, is be smart, bring them back when it's appropriate, and otherwise it doesn't make any sense at all. I have a question about, does dental liability / malpractice insurance cover if sued by patient or staff that claims to have contracted the virus through the office? I presume. I can't see the rest of the comment. Talk to us about the liability of employees or patients allegedly contract, because I think it'd be awfully hard to prove where it came from, but maybe I'm wrong. What's the liability there if somebody gets it from your business? If I go get it from Walmart and I want to sue Walmart, how's that going to play out?
Sure. So the short answer is it's going to depend on what your specific policy says, because different policies have different exclusions. Some have virus exclusions and different things like that. Typically, your liability insurance is going to be covering if you're doing somebody's teeth and you chip their tooth or something like that, then that's something that is directly arising out of your business, if you have your operations there, or if they were to slip and fall on the premises, that's going to be covered. And a lot of times, and like you hit the nail on the head there with proving where they contracted the virus. I mean, that's it. The fact that it's going to be difficult to prove doesn't mean that we're not going to see claims. I mean, there's going to be claims all over the place for the foreseeable future, unfortunately. But you want to make sure you're taking a look at your liability insurance to see if there is some sort of a viral exclusion or something like that, because if there is, then that's the problem. And I think I've seen policies across the board. Some are very inclusive and some are very limited in what they cover. And so it really just depends on what your policy says. So I'd say reach out to your insurance broker or agent to kind of have them walk through it with you, or an attorney that understands business insurance, so they can take a look at that and kind of give you an assessment of what would be covered, what might not be covered, where some holes might be. But I think the entire insurance world as a whole is kind of in a state of flux right now, because this pandemic isn't something that most insurance companies were ever expecting. Any of us were expecting, I suppose, would be more appropriate. And there's a lot of interpretation that's going to be happening that talks about what is covered, what isn't covered, that when it comes to being related to COVID stuff. So that's something that's going to be an evolving issue over the next few years, probably.
You know, I have to assume that common sense is going to be hopefully something that applies here, although I know that that's a ridiculous statement already, because nobody could be prepared for something like this, either from an insurance perspective, from a provability perspective, from any of these sorts of things. And you know, there's absolutely going to be some attorney with the word strong arm in the name of their firm that's going to be out here going after it, saying, hey, contact us, perhaps. No names, because I don't want to be accused of slander at this point. But, you know, I see issues where sadly, there's going to be some stuff that's going to probably take place. And my hope is that the court systems will approach this with a bit of common sense of, hey, there's absolutely no way you're going to prove to us that this is where this came from. Good luck. And I think then the best defense you have that we can give people is to have a good infection control documented procedure in place that you follow on a regular basis that becomes your book of evidence to support you on the backside of this would be my advice. I assume you would agree with something like that.
Absolutely. Even when you're dealing with a slip and fall case, if you can show that you have maintenance records where you are keeping the floor clean and free of debris, that goes a long way in a court of law and in limiting your liability. So definitely document everything. I'm sure I'm a lawyer. Everybody expects me to say document, and make sure that you're holding on to those documents for the foreseeable future, for sure. And just make sure that you're being consistent and doing exactly, you know, it's not laissez-faire as to what you're doing. It's the same process every time. And you were making sure that you're keeping that clear, documented, and in a safe place that you could find it when something comes by, because chances are we're a litigious society. Yeah, it's not if, but when.
What is the statute of limitations for?
Can I just add really quick? In addition, right now, everybody, as we're preparing to reopen our businesses, that's one thing you really should be looking at is policies. Making sure that your health, wellness, and safety policies are up to date. None of us really had anything like this in our handbooks. Biological matter, pandemics, social distancing, wearing masks, wearing gloves, that did not play in. And the basis to your documentation always starts with your policies. So put these policies, add these policies into your employee handbook. And there's a few places like the local SBDCs have been providing template policies and such. Start there, then customize it to your business and how you see operations going forward. But I guarantee also going forward, you're going to have to continuously update these policies because there is going to be evolution as we move through this.
You know, I want to stop real quick for commercial break and reintroduce you guys for those that might have joined later. Rihanna, who is in the colorful shirt, because I don't know which orientation you might be in, is from HR, is the owner of HR Branches. She's an outsourced HR company. So if you don't want to have to deal with all these HR things, if you don't want to have these templates, if you don't want to have to deal with this brain damage, I would suggest you contact her and let her do it all for you, because clearly she's an expert. And then Christina Gilbertson is joining us, who is a lawyer whose specialty, if I'm not mistaken, is HR/employment sort of law topics. And they obviously piggyback together, and the two of them is a pretty dynamic combination to any of these issues. So if you have specific questions, I would reach out to either of them individually, and we will make sure that their contact information is available to everybody here, should you have them. I had another thought. Christina, generally speaking, with something like this, which is a stupid statement to start with, what is the statute of limitations? And maybe the best and closest thing we could use would be a slip and fall, or what's the statute of limitations that people need to be prepared, mentally prepared to be keeping all these records for? What duration would you suggest?
Well, the statute of limitations may vary some from state to state. In Colorado, a slip and fall is a 2-year from the date of incident. So if I fell today, then I would have from 2 years from today to file suit. And just as a heads up, 90% of your plaintiffs are going to wait until 2 years from today to file suit, just because that's just how it works. And so you definitely want to be sure that you're holding on to these records. I'd say for a minimum of 5 years at this point, but keep an eye out there. There may be some new. There could be some new statute of limitations created for something like this. I doubt that's going to happen, but here in Colorado, it's a 2-year statute of limitations for this for a personal injury claim, which is essentially what we'd be dealing with here. If there's some other basis that somebody could try to bring a claim, that could be different. So looking at it just from the personal injury side of things, I'd say at least for 5 years, if not longer.
Great. I have a question. When we return, if an employee wants to use vacation time, is there any obligation to allow them to use their vacation time? I'm going to try and paraphrase that. I think the heart of the question is coming back, we expect we're going to be slammed and busy. And if I go with that assumption for the sake of illustration, I need all hands on deck. Do I have the right to look at my team and say, hey, no vacation for the next 2 months? We got to get things going again.
As the employer, and generally in most cases you do, but again, going back to the policies, hopefully you've got a PTO policy written that does state that the employer does have the discretion to approve your PTO time. Even if you don't have that policy, you still do have the right to approve that PTO time. So yes, you do have the authority for that approval component. But also be aware of the culture of your organization. Say you've got this employee who has had this vacation planned since last November. It's already paid for. If you ask them to cancel their vacation, especially after everything we've gone through, that might be hurting your relationship with a good employee. So weigh those pros and cons and think about that lasting impact and how it will impact your operations. It may be a small week-long blip on the radar as you're trying to gear back up, but it may be a long-term positive, or the other way around.
Fair. What other questions are you guys commonly getting and answering that we might have missed here? And Barb, do you have any?
Mine's a little bit more technical just because I've been speaking to so many of our teams in the last 2 weeks that they're required now to take temperatures of patients, as well as, I don't know if it's a requirement or a suggestion, but a lot of the teams that we're leading are taking temperatures of their employees. And if the employee has a temperature, I understand they have to go home. Can you give us some details on how long is it a self-isolation for 14 days?
That would be my recommendation, is if anybody is showing any COVID symptoms, do the 14 days, urge them to see a doctor if they think that it really could be COVID, just so that everybody is clear. I mean, we want to make sure that we're being extra careful right now, and I think that's probably going to be the best way to go.
And I assume that's why this law came out with the additional 2 weeks of paid time off, was to cover this sort of circumstance. Got it. That was my assumption.
And then if Susie does have a temperature in Dr. Jones's office and she goes home, she just came back to work on day 3, she gets a temperature and she has to go home. Is there legal obligations for that employer to continue her payroll?
I think it's going to be situation dependent. If it's something that it is just the flu, or just something, an infection of some sort, then that's going to be a little bit different. But if it does turn out to be COVID related, then yes, that's when the legal side of things is going to kick in. And that's where I think you're going to have to be asking for the documentation from the doctor and kind of going down that path.
Yeah, that's why it's imperative as soon as they register a temperature, you send them immediately to an urgent care to start the doctor's process, right? Have them go to either their primary care physician, an urgent care facility, and start that testing process immediately for the health of your business. You want to get that test completed as soon as possible because that's the qualifying factor in most cases for the extended FMLA and sick time.
Thank you.
Barb, you got anything else?
No, we've covered the questions that we had. Thank you all so much. It was very helpful for me.
Well, I want to thank you both again for joining us. You guys have just been awesome in terms of knowledge and experience, and I hope everybody hires you to make their HR lives easier, because I'll be one of the first ones to be jumping into doing business with you, because this has been outstanding. And not only are you guys just fabulous to be around, but your knowledge is obviously just out of this world awesome. So I can't thank you enough for it. We do have your contact information, your emails for both of you, probably phone numbers too. I can't quite see it though in the feed here. And if you guys want a copy of this video for your own purposes, more than happy to send it to you. I did screen record it here as well, because you wouldn't have known it, but we were having Facebook audio issues, so I'm not entirely sure what everybody got to hear. So I was really glad I was recording it, because I will upload this video. I'll compress it and send it to both of you. You can do with whatever you would like with it. So barring any other questions that pop up here, any last concluding thoughts from you two?
My initial thought is, as we're reopening, all of us have been in a really tough situation. And it's funny, with the economy shutting down, I think all of us have been busier than ever. And we've been in the weeds trying to figure out how to keep our businesses operational, at least in some capacity. Take a moment, step outside of the picture, look at the whole picture, and think about working on your business, not in your business today. Right now, it's essential to plan when it comes to everything from what does the future look like for your business? How am I going to adjust my business? How am I going to bring my employees on board and have them working towards this new, and then all of this legal infrastructure intermingled in between? Making sure you've got operational plans, procedures, and policies in place are huge, and they are key to your success.
Or the defense of your success. It's one thing to generate a lot of revenue. It's another thing to keep it and not lose it through a lawsuit. So, yeah.
I think just kind of adding on to that, I think we need to be prepared that it's going to take a long time for us to get back to normal, and it's going to be incremental. And so we have to give ourselves the grace to figure out there's going to be some stumbling along the way, and definitely urge you to reach out and get help, whether it's from your local SBDC or if you have a team of professionals around you. There's a lot of information out there, and it can be hard to digest, and there can be conflicting information out there. So don't feel like you have to resort to the law of Google to try to figure out how to save and protect your business. Get the help that you need out there, and make sure that you're crossing all those T's, dotting all those I's, and doing everything you can to protect your business going forward.
Dumb question for those that might be like me out there. What does SBDC stand for?
It's a Small Business Development Center. It's a local arm of the Small Business Administration through the federal government.
Got it.
And they have a lot of free resources and training and consults and things like that for small businesses.
Would that be the same thing as the local CDC office, like the Pikes Peak Regional Development Corporation, or is that something different?
They're separate. They're completely separate entities. But it's the Pikes Peak Small Business Development Center. They're fantastic for the Colorado Springs area. I'm one of the consultants for them, so I might be a little bit biased. But they have, if you have a question, whether it's HR related, accounting related, legal, anything with your business, you can get a free consultation with a professional in that area. And they've got all kinds of resources, webinars, classes. It's a great resource for a lot of businesses that a lot of businesses don't realize is there for them. So definitely,
I didn't know it.
Google it and look at that. Yeah,
that's awesome. No, I appreciate that very much. Well, thank you so much for both of you joining us, taking the time out of your busy schedules. I hope that this has been helpful for you guys, or will be helpful for your businesses as well. And we'll do everything we can to try and put some marketing prowess behind this, and hopefully help you guys out as well. So again, thank you so very, very much.
Don't forget to wash your hands.
Exactly.
Thank you for inviting us to join you today.
Yes,
It's
it
our
is our
pleasure.
pleasure. Thank you.
Yeah, thank you.